Hello, welcome. See, we have people joining us. Thank you so much for being with us today and signing up for today's webinar on Homeowners Association Law Update. I'm Lisa with the library, and with me today are our two great speakers, Laurie Poole and Jay Brown. And once we get through with a little housekeeping, I'll be turning over the presentation to them. A couple of things you need to know before we get started today. I'm sure some of you have been attending our webinar, so I'm sorry if you're hearing this over and over, but every once in a while we have new people attending, so I like to say a few things. First, you will be getting a CLE certificate for attending today's webinar, as long as our Zoom report shows that you actually attended. So we will be sending those CLE certificates out by email this afternoon, and you should be looking out for that. Another thing you need to know is you will see a link to a survey pop up at the end of the presentation. And if you could take a couple minutes to take our survey, we'd really appreciate it. And thank you in advance for that. This is also interactive presentation. You can post questions in the Q&A function here on Zoom. You'll see a little icon on your desktop that says Q&A with two speech bubbles, and that's a place where you can click and type in a question. If you'd like, you can do so with your name or anonymously. We do ask that you keep the questions general, and Jay will be talking about that a little bit more. Questions are for general information purposes and not for advice today. I think that's about it. Okay, thank you again for attending, and I'm going to turn things over to Laurie and Jay.
Hello, my name is Jay Brown. I am an attorney at Community Legal Advisors. I've been working with homeowner associations for about 30 years now. Perform all sorts of functions for homeowners associations, whether it's revising CC&Rs, enforcing governing documents, firm assessment collections, and so forth. One little caveat that Lisa mentioned, because Laurie and I and our firms represent a lot of homeowners associations in San Diego County and Southern California, we'd ask you that you please not ask a particular question about your homeowners association, because we have no idea if we represent them or not. So like Lisa said, please keep those questions general if you have any, and we'll try and answer them.
Yeah, hi everybody. So my name is Laurie Poole, and I've been a community association attorney for 30 years. I am a co-managing partner of Adam Stirling. We are a statewide firm that represents homeowners associations. So yeah, like Jay said, we are just providing some general information about some of the laws that were enacted last year. This year, that'll be effective as of January 1. Also a caveat, remember, we are not the legislature. We did not enact these laws, so don't attack the messenger. So,
right.
All right, so why don't we talk about homeowners associations? So hopefully all of you joining are aware and know what a homeowners association is, but if you don't, they are the governing bodies of a lot of residential. They can also be commercial as well, but for our purposes today, residential communities where people, when you purchase real property in that community, you become bound by the the requirements of that community, which can be in recorded documents or rules and regulations, things like that. We'll touch on that a little bit later. But it is the most common form of housing model going forward. Every new development has an HOA, and that's not going away anytime soon. So they are here to, they are here to stay.
Yeah, and they're a great opportunity in the condo market for first-time home buyers. It's usually a good entry level to get in. Local governments like associations because it shifts a lot of the burden of providing services to the homeowners association. Laurie's going to cover some facts and figures about specific to California, but as the slide says, most residents are satisfied with the HOA experience based upon surveys performed by the Community Associations Institute. And in my experience, that's generally the case as well with the clients I deal with, and also my own experience having grown up in a homeowners association where we had a pool and green belts and basketball courts and so forth that we couldn't have afforded without that. Also, HOAs provide a lot of the maintenance, regarding the exterior of the buildings and so forth. So that's helpful. When I talk to people and tell them I represent homeowners associations, of course, they tell me about all the bad actors in their HOA, or how the property manager is stealing funds, and how a board member runs the place like a dictator. And it's true that happens occasionally, but by and large, HOAs run the way they're supposed to, with a dedicated board that doesn't get paid. They're all volunteers. And by and large, they do a really good job. So turning to the statistical review, as you can see, starting in 1970, which was the first year, there were 10,000 communities in the nation. Now, with the steady growth, about a fifth of the population, about a fifth of the population lives within a community association. And just from driving around, anecdotally, it doesn't look like the growth is going to stop anymore or anytime soon. Anybody that's driven up the 15 or down in Chula Vista, or even up here in coastal North County, where it's maybe a little more infill construction, but even those are mostly condominiums that are coming in. But you can drive anywhere, and most of the development for housing units, I would say, is related to community associations. The next slide.
No, I went. Oh, no, I did.
National data. Yeah, I just wanted to point out a few things. So the largest homeowners association in the nation is a community called Poincana Communities, and that's in Florida. And they have over 20,000 homes within their community, which just seems crazy. But just to highlight a few items and the huge economic impact that homeowners associations have. They're, like I said, 29% of the US population is in community associations. The value of homes in community associations, over $11 trillion. There are 6,000 to 9,000 large scale HOAs, which are defined there for you. They mean meeting at least two of the following three characteristics: single continuous community with a general manager, a minimum of 1,000 lots and or homes, and a minimum annual budget of $2 million. So that's a lot of money for volunteer board members to be managing, and a lot of responsibility. And there are no requirements that these board members have any sort of special training. And they rely upon the property managers and the attorneys to help guide them through the new laws that keep coming on the books each year. Some other percentages I just wanted to highlight. 67% of the homes completed and 78% of the homes built for sale are within community associations. So that, like I said, if you drive around, you'll see that. And these statistics come from the Community Associations Institute, which is kind of the overarching organization that Laurie and I and our firms are involved with. They provide a clearinghouse for a lot of these statistics. They provide education and so forth. And in prior slides, you could find their contact information. But I just wanted to give a plug for that. And then I think Laurie's going to go into some individual state comments.
Yeah, did you have anything more on okay, on this one? All right. So as you can see in this slide, as of 2022, California has over 50,000 HOAs, and those 50,000, there are over 14 million, I believe, maybe it's billion residents in those communities. I guess that's million, and over almost 5 million units in California. So 36.3% of all occupied homes in California are in an HOA. So that's over a third of the homes in California being in an HOA, and that number is only going to increase. Like if you saw Jade, in looking at the slides that Jade talked about, they are. You can see nationally those numbers increasing, and it's certainly going to in the case in California. In California, this is where the billion comes into play. The value of homes that are in HOAs in California is over $3.6 billion. That's what the homes are worth that are in HOAs in California. So this is big money that we are talking about. That again, like Jay said, these volunteer directors are charged with making very important decisions for their communities that have financial implications for what many people, it's their highest valued asset is their home that's in an HOA. So that's why, frankly, he and I have jobs, and that's why what we're going to talk about today, the laws and the cases and how they affect these associations, are so important and have far-reaching effect here in California and nationally and even internationally. Jay mentioned CAI. That's actually an international organization. There are homeowners associations in Canada, Australia, the UAE, all over the world, Italy. I'm willing to open our firm's office in Italy. So, once we start representing HOAs in Italy, I'm there. But they're not going away. They're here to stay. And it's really important to understand the laws that govern them. So we are going to talk quickly about the governance, what laws do govern community associations in California. Not going to Italy yet. We're going to talk about the sources of law. We are going to review the new legislation that will be effective January 1, and we're going to highlight a few of the published cases that came out this year in 2023 regarding homeowners associations. It makes for some very entertaining case law, I will say. Okay, so some of the resources that we rely on as practitioners in this area of the law is the CEB, Advising California Common Interest Communities. It is a very good general guide about common interest developments. It's been around for a long time. It's often cited to or looked at by appellate courts in their opinions. We mentioned CAI, which is an international organization. Various law firm websites. I'll do just a quick plug. Our law firm has a website that is a resource for California associations. And then, of course, San Diego Law Library, our host today, to be able to do legal research at the law library. So, all right, so let's talk about the laws that govern common interest developments in California. And I want to say that this isn't the hierarchy, the order in which we've listed them here. That's not the hierarchy that's set forth in California law. The hierarchy in California law says the law first, then the set of documents, the recorded covenants, conditions, and restrictions. If you've heard the term CC&Rs, that's what that stands for. That comes next. And then if it's a corporation, many of these HOAs are nonprofit corporations. Most of them are nonprofit mutual benefit corporations. that will have articles of incorporation. That's next. Then the bylaws, and then various rules and regulations, things like architectural guidelines, rules and regulations, enforcement policies. All of those are at the bottom of the hierarchy on the same level. So when we're working with common interest developments and we're asked questions and opinions, that's one place we're going to start is the governing documents. And that's the documents that are particular to each community. That is the recorded CC&Rs, the bylaws, and the function of the bylaws is really to talk about how the entity operates. How do they hold their elections? What are the terms of the directors? What are the jobs of the officers? Things like that. Very similar to what you would find for other corporate entities. The articles of incorporation are the birth certificate of the corporation, and it usually they don't have substantive information, but they might indicate the purpose of the corporation. They might talk about, the number of directors, things like that. And then the rules and regulations, and we have ... because like I mentioned, there could be various documents that fall under that umbrella of rules and regulations. But those are the rules and regulations and the architectural guidelines, enforcement policy, collection policy. All of those are kind of more user-friendly documents that supplement the general concepts that are in the recorded CC&Rs. So they're going to have more specific information. They're going to talk about the day-to-day living within the community association. So those are the governing documents generally. We don't have on here, but we should for a condominium. There's a condominium plan that is the recorded diagram of the building, and it gets into what the boundaries of the units are versus the common area. So that's also a very important document that we as practitioners look at. So moving into the law, you'll see Civil Code Section 4000 at SEC. That is the Davis-Stirling Common Interest Development Act. And that is a set of laws in the Civil Code that is specific to residential common interest developments in California. The Davis-Stirling Act was originally enacted. It became effective January 1 of 1986. And then on January 1 of 2014, it was reorganized. It moved. So those of us who knew all the old code sections, we had to learn all the new code section numbers because it moved to a different location in the Civil Code. And it was reorganized. And I have to say, I think it was reorganized really well back then. And I can't believe it's going to be 10 years next year that what we call the new Davis-Stirling Act has been in effect. We also get involved, our HOAs get involved in a lot of different areas of law that we need to know about. The Unruh Civil Rights Act, I mentioned that they're corporations, the nonprofit mutual benefit corporate code sections we need to know. For those that are mobile home, maybe mobile home conversions, we need to know about the mobile home laws. There are specific sections in the Civil Code about solar energy installations that tie into the section in the Davis-Stirling Act on that. Additionally, the various city, county codes and ordinances we may need to look at when we're dealing with certain issues. And then there's case law, like I mentioned. We're going to be talking about a few cases this year that are of note. But the two landmark decisions that we list here, Nardstedt and Lambden, those are very significant Supreme Court cases in California law governing homeowners associations. Nardstedt set forth the test to determine whether the recorded CC&R provisions are reasonable. That's what we use to guide our clients in what they want to do as far as adopting a CC&R amendment. Nardstedt gave us the test to use. And then Lambden, the Lambden decision sets forth the principle that there's going to be judicial deference to decisions that the boards of directors of common interest developments make if they, as long as they have exercised business judgment and a certain standard of care and have acted with authority in good faith after doing their due diligence. then courts are not going to second guess the decisions that the boards have made, and they will defer to the decision-making process and result that the boards have done. Anything else on law sources, Jay?
I just want to jump in. The Unruh Civil Rights Act, that is a primary source for senior communities. That contains the language that allows associations to keep underage people out of their communities. So if you have represent a senior community or know somebody that lives in a senior community, you would want to look at the Unruh Civil Rights Act, and be careful, because there's some provisions that only specifically apply to Riverside County. So be careful, read all the way through to the bottom to make sure you're not relying upon one of those.
Or the pocket part. Remember the pocket part back in the
Oh,
day?
yes, pocket parts.
I'm dating myself, I realize that, but. Okay, so now we're going to talk about the actual laws, the bills that were in front of the California legislature that were chaptered and will be effective on January 1. And so the first one is AB 648. It amended Civil Code Section 4090, and it adds a new statute to the Davis-Stirling Act. You know, when the Davis-Stirling Act was first enacted in 1986, I think there were like 22 statutes. Now there's over 250, I believe. One of it is when it was reorganized, they did break up some of the longer statutes into lots of different code sections. But here we have yet another statute that we will need to learn and follow. But this is a good one for community associations heading into the new year. And what it does is it's currently, before January 1, as a result of the pandemic, Civil Code Section 5450 was enacted, which allowed boards to hold their meetings solely virtually when there was either a federal or state or local state of emergency that made it impracticable or unsafe to meet in person. Then they could have their meetings in person. The law, until January 1 of 2024, the law required that in non-emergency situations for open board meetings where the members can attend, that there needed to be a physical location where at least one representative, it didn't have to be a board member, it just needed to be a representative, was physically present at this physical location. So AB 648, with the enactment of Civil Code Section 4926, says that boards will be able to have virtual only meetings. In other words, they will be able to not have to comply with that physical location requirement for their open board meetings. And this legislation was really proposed because during the pandemic, when HOAs were meeting virtually, they found that they were getting a lot more participation by their homeowners, because their homeowners who maybe didn't want to drive to the meeting location, it was easier for them to just zoom in and watch what was going on. So the legislature agreed and said, yep, you can have board meetings. It also applies to actually membership meetings as well, that board meetings and membership meetings can be held virtually. The association has to comply with certain notice requirements. The notice has to include things like having allowing people to be able to call in, not just using computers. They need to be able to call in on their phones. You need to have a phone number where technical assistance during the meeting will be available, things like that. So there are some requirements in order to have these virtual meetings. Also, the vote of the board needs to be by roll call, so how each board member voted. As long as the association complies with those requirements, we'll be able to have virtual meetings. And then the last bullet, though, the legislature did accept out any board or membership meetings where ballots are going to be tabulated and counted. So like the annual election of directors, where there's ballots tabulated and counted, those are not going to be able to be held solely virtually. You could do a hybrid. You'd be able to do a hybrid where you could have virtual, but you still will have to have a physical location where members are able to attend.
And if I can just jump in right quick on that, Laurie, the virtual meetings, I think most property managers I deal with like virtual meetings. First off, like Laurie said, they don't have to travel. They can sit in their offices, but also when everybody had to attend, if there were some disruptive members, you know, you'd have to shut down the meeting, ask them to leave. Certain instances get security. You know, you can mute somebody that's being abusive. As the property managers tell me they do that. So they like that, and like Laurie said, it's allowed greater participation, and I think has made meetings go a lot smoother.
Yeah. All right, so Jay, you're going to talk to us about 1458?
Yeah, so 1458 set to go into effect January 1st. It amends Civil Code Section 5115 and Corporations Code 7512. So 7512 provides, unless otherwise provided in the bylaws, the quorum is 1/3. And so HOAs have had a hard time reaching quorum in a lot of instances. And the way, you know, and it's expensive, you know, they have to keep trying. And if they can't reach quorum, you know, there are certain things they can do at this point. They can try and pass an amendment to lower the quorum requirement or get rid of it altogether. They can keep trying to have multiple elections, which gets expensive. You know, we oftentimes advise board members that they're going to have to go door to door and remind people that, hey, there's an election. We need your ballot. Please make sure you return your ballot to try and reach a quorum. And it's difficult if a lot of the members live off-site to get them to return things. You can also petition the court to reduce the quorum, but again, that's expensive and time-consuming process. So what has happened now is the court has decided that this new code section will allow the board and the members to adjourn a meeting for lack of quorum and have that quorum reduced to 20% of the voting members or lower if it's allowed in the governing documents. So this applies to elections of directors, recall of directors, and other meetings. The adjourned meeting must be at least 20 days from the prior meeting. But I think this particular requirement is going to help smooth out the process of the transition of board of directors, because what happens now in a lot of cases is board members are stuck on the board because they can't get a quorum to elect new board members, and you know they serve until somebody else is elected or they resign. So I think this will have a beneficial impact on the operation of homeowners associations in the long run. The next code section, assessment collections. So this amends Civil Code Section 5605. And currently, HOAs can increase assessments up to 20% of the prior year's assessment without a vote of the membership. They can impose a special assessment up to 5% without a vote of the membership. And you know, the assessments are obviously used to pay for the expenses of the HOA, and under the Civil Code, HOAs are required to assess enough to function, essentially. But what this new code section will do, it will restrict the amount of assessment increases that apply to affordable housing, for affordable housing units. So the supporters of this bill claim that the increasing assessments and I don't know very many HOAs that actually decrease assessments, but assessments are going up. But they claim that the increasing assessments prevent generational wealth, that lower income persons aren't able to pass on the home and the equity in that home to other people, so it's a barrier. And they say that the below market rate units have a higher foreclosure rate, and they blame that on the fact that they're increased assessments that the lower income persons can't keep up with. So this bill would restrict increases on affordable housing units and communities to 5% plus the cost of living, but it can't exceed 10%. And there's a calculation for the cost of living in the new code section. Excuse me. It doesn't apply to special assessments or emergency assessments. So one of the fears, or actually not one of the supporters of this bill acknowledge that what some boards may end up doing is, keeping the regular assessments low, but then funding a lot of the projects or the upkeep through special assessments, or even letting things, go to disrepair and imposing an emergency assessment, which wouldn't be subject to these assessment limitations set forth in 5605. So yeah, this goes into effect, or doesn't go into effect until January of 2025. And it only applies to, only applies to declarations that are recorded after January 1st, 2025. So be on the lookout for that for newer homeowners associations that you may be representing in the coming years.
And it also won't apply to associations that are under 20 units, even
Correct.
after January 1.
Correct.
Yeah. So, all right, let's talk about term limits.
Term limits. Okay. So right now, under the civil code, HOAs can have certain optional provisions in their election rules. So all the HOAs are supposed to have by now adopted election rules under the civil code prior to holding elections. I can tell you in a lot of the older and smaller HOAs I represent, that's not the case, but they're supposed to. And there's certain optional provisions within those election rules, right? And the election rules are designed to tell you who's qualified to run for the board. It tells you usually, the quorum requirements, what person needs to be elected, whether or not cumulative voting applies. But there are certain optional provisions. Those include a nominee must be current in the payment of assessments. And another one is that the nominee cannot be on title to a unit if another person on title is already serving on the board. All right, these are optional provisions, by the way. You can restrict a nominee if they've been a member for less than a year. And you can also restrict a nominee if they have a criminal conviction, which prohibits the board from getting a D&O policy. Excuse me. So those are all optional provisions that the board can choose to put in their election rules, and then put that out for comment by the members. What this code section will do is add term limits. You can limit the term of a 2-year term to, the board member can only serve for 3 2-year terms or so forth. And if that nominee is disqualified pursuant to those restrictions in the election rules, those same restrictions would also apply to the board members that are currently serving on the board of directors as well. So this one will add the term limits as a as an option as well to the election rules.
Okay, so we're going to move on to AB 1572, dealing with non-potable water. And I will say that this bill kind of flew under the radar, I think, for associations until it was kind of close to being enacted, and then became enacted. And also, I think for me, one of the reasons why I've enjoyed being a community association attorney for as long as I have been is it's really diverse. We deal with so many different issues. And I will tell you that dealing with the water code was probably something I didn't think we'd ever have to deal with. But now because of this bill, it made changes to the water code that now we're going to need to be aware of and involved in. You know, under existing law, there's a policy that water use for domestic purposes is the highest use of water. The legislative history for this bill talked about using potable water to irrigate non-functional turf is wasteful and incompatible with state policy relating to climate change, water conservation, and reduced reliance on the Sacramento-San Joaquin Delta ecosystem. So this bill amends and adds various provisions of the water code, as you can see here. And for purposes of homeowners associations, this bill affects HOAs because it says, in essence, that as of January 1st, so from and after January 1, 2029, the use of potable water to irrigate non-functional turf on common areas of HOAs is prohibited. And the bill is actually a lot more comprehensive than HOAs. It applies to non-functional turf in many, many, many different contexts. I think pretty much other than cemeteries and maybe golf courses. Well, actually golf courses would be functional turf, but so there are a lot of other entities that are going to have to comply with this, but we're just focused on how it's affecting HOAs. So what does that mean? You know, you can't, you can't use potable water on a non-functional turf. So we want to know what is non-functional turf. So non-functional turf is defined as any turf that is not functional turf. That's what the new bill says, the new laws say. So we really look at the definition of functional turf to figure out what areas are going to have to be converted to irrigation with non-potable water. Functional turf is ground cover surface of turf located in a recreational use area or community space. So we look at the definition of recreational use area. It's an area designated by a property owner, in this case the association, to accommodate human foot traffic for recreation, included but not limited to sports fields, golf courses, playgrounds, picnic grounds, or pet exercise areas. So if the turf areas in an HOA are recreational use areas or other forms of functional turf, you're not going to have to convert your turf area into being irrigated by non-potable water as of January 1st of 2029. But if it is a non-functional turf area, and there are a lot of associations that have, you know, a lot of turf areas that are green belts and things like that, those are, if they are non-functional turf, they're going to have to be converted to non-potable water as of January 1. My hunch is because pet exercise areas are recreational use areas, which are deemed to be functional turf, is I think we're going to see a lot more dog poop bag dispensers in some of these greenbelt areas to say that they're pet exercise areas and therefore they are functional turf. The other thing is, I think the effect of this, and probably the intended effect, is you're going to see a lot of these turf areas removed and converted to more drought tolerant type landscaping to avoid having to comply with the non-potable water irrigation. Jay, anything else to add on?
No, I agree. I think there's going to be more dog play areas.
Yeah, more doggy parks.
Yep.
Okay, so one of the other changes that affects everybody, but it certainly affects homeowners associations, was SB 71, which adjusted the small claims court jurisdictional limits. So currently, entities not other than natural persons, so any entity not a natural person, the limit of recovery of damages in small claims court is $5,000 as of January 1. That's going to be increased to $6,250 for individuals, for natural persons. And this is usually the homeowners who are suing the HOAs. Currently, the limit is $10,000, but as of January 1, it will go up to $12,500. And SB 71 also raised the threshold for limited civil cases from $25,000 to $35,000. So, and SB 71 amended various sections of the Code of Civil Procedure, but the ones that we focused on were 116.220 and 116.221. Okay. So this is another interesting bill, and again, another other provisions of California law that we as community association practitioners need to be aware of. And this is the government code. There have been changes to the government code over the last few years to make it easier for local entities, cities and counties to permit accessory dwelling units or junior accessory dwelling units. That's ADUs or JADUs. So we've been seeing changes to these government code sections over the last few years to make it a lot easier, and you probably see that as you drive around San Diego County. You see a lot more ADUs being built because of the push to make it easier for homeowners to be able to construct an ADU or JADU on their property. And we've certainly been dealing with it in the context of homeowners associations. But this bill, AB 1033, now will allow currently the separate sale of an ADU. So if somebody constructed an ADU on their property, they would not be able to sell that ADU as a separate, parcel or a separate dwelling, unless except in very limited circumstances. Well, this bill actually expands that, and it will allow cities and counties to permit the separate conveyance of a primary dwelling unit and accessory dwelling unit or units as condominiums. So in other words, if a homeowner builds an ADU on their lot and they want to be able to sell that ADU, they will be able to turn it into a condo, basically. They will have to comply with certain requirements as stated in the government code, things like they're going to have to get lender approval. The lien holder is going to have to approve. They're going to have a safety inspection from the local entity. There's going to have to be a notice to consumers from the local entity in the permitting process. But we may be seeing what I'm calling the condoizing of ADUs. And so how it affects common interest developments is, well, what does that mean? If there's an existing common interest development and now there's going to be this condominium development within this common interest development, how does that work? Well, the AB 1033 did think about that, and they said that where the lot, where the homeowner wants to build an ADU and then condoize it, is within an existing homeowners association, that before that owner can record a condominium plan for the ADU and the primary dwelling, they will have to get express written authorization by the existing association. And the express written authorization is defined to be approval of the association's board, and if required by the governing documents, approval of the association's members. So I know, I suspect we're going to see governing documents for our planned development clients where ADUs can be built. I think we're going to see a lot of those amendments to those documents to have a membership approval requirement for any owner who wants to condoize their ADU and be able to sell it as a separate condo. Anything to add there, Jay?
No? No.
It's going to be interesting to see how often this is done.
Yeah, well, I do have one comment in the HOAs that I currently represent. Haven't had a large influx of ADUs that at least they've contacted me about. Presently there's not much the homeowners association can do if somebody wants to build an ADU, other than make sure it's in harmony with the rest of the community as far as
Right.
appearance. So I don't know how much of an effect this will have on communities. There's a lot of paperwork to go through before somebody could actually create a condo on their lot. And they may decide it's not worth it. It'll be interesting to see how this plays out.
Yeah. All right, let's talk about the Corporate Transparency Act, Jay.
Oh my gosh, the Corporate Transparency Act. I vaguely remember somebody mentioning this a few years ago and didn't think much of it. But now it's come back and it's set to take effect, the reporting by January 1st, 2025. And to drive home the fact, the CPA that I work with sent a notice out to all his clients saying, hey, there's this Corporate Transparency Act and we're not responsible for compliance. You need to take care of it. And I was like, oh, okay, this jives with this presentation I'm giving. I guess it's real. So anyhow, this Corporate Transparency Act was adopted several years ago, and its aim is to deal with money laundering and funding for terrorism and to prevent that. Now, I don't know how many property management companies or HOAs get involved with money laundering. I'm guessing it's a pretty small percentage. And I know CAI, Community Associations Institute, is working to try and get homeowners associations exempted from the Corporate Transparency Act, and hopefully they'll be successful. Because this section will make it, I think, even more difficult to recruit board members, because oftentimes board members or homeowners will not want to serve on the board because they don't want people to know they're on the board. They don't want to provide certain information. They kind of want to remain anonymous. Well, if you're on a board and the Corporate Transparency Act is still in effect come January 1st, 2025, and it applies to homeowners associations, you're going to have to file documents that list the name of the homeowners association, the names of the board members, birth date, home address, identification from a driver's license, so forth. That's a lot of information that people may not want to disclose. Some other requirements are, you have to identify an individual with substantial control. So is that the property manager that writes the checks, the majority of the checks for the homeowners association, or has that authority? Or is it the board of directors, the president of the board, who exercises control? If you don't have a property management company, my guess is that's going to be president or the treasurer. So that's another issue that needs to be cleared up. You have to, if there are changes to the board, then those, you have to file a correction or an update, and those need to be done within 30 days at the time you become aware. And this is all in addition to what's required by the state of California, which is that HOAs have to file a statement of information, which lists certain information about the HOA, specifically the agent for service of process. So it's a big concern. Hopefully CAI will will have success in lobbying to exempt homeowners association. Because if they don't and homeowners associations don't comply, there are penalties, and $500 a day, potential criminal penalties. And I can tell you some of the smaller HOAs that maybe don't have property management companies, some of those HOAs don't even file their statute or their statement of information. Good luck trying to get, having them figure out how to do the Corporate Transparency Act. So it's a big concern. And again, you can CAI has a nice brief description of the Corporate Transparency Act and what's required. And they also have a petition you can sign to help exempt homeowners association from this, because I can't believe that the legislatures really thought that money laundering was going through homeowners association, but I'm not privy to all the information they have. But
and this is a federal law. This is federal law.
It is a federal law, yes.
Yeah,
so
this is applying across the country to every HOA. Yeah.
So,
All right, we're sorry, I didn't mean to cut you off there.
No, I said just be aware of that, and go on CAI and sign that petition.
Okay. All right, well, let's move on to some cases, some notable cases from this year. And I'm gonna keep the summary really brief in the interest of time, but this case is, we put it first because it was probably the most impactful case or eye-opening case. I don't know how we want to call it, but certainly ripple effect case this year, I think. And actually update as of yesterday, just in fact, the California Supreme Court denied a petition for depublishing this case, and it also denied the petition to review this case. So this case is now set in appellate court law, but it's LSNU number 1 versus Alta Del Mar Coastal Collection. Alta Del Mar Coastal Collection is an HOA here in San Diego County. And in this case, it's a small association. There's 10 homes and 5 directors. And the plaintiff was an LLC, which owned one of the homes. The complaint that was brought against the association was violation of the Open Meeting Act. And in the Davis-Stirling Act, there is a section called the Open Meeting Act, and it governs how the association is supposed to hold the board meetings. And that AB 648, talking about the virtual meetings, what I talked about earlier, that's in the Open Meeting Act. Now, a lot of people confuse the Open Meeting Act of the Davis-Stirling Act with like the Brown Act or other acts that govern governmental entities, but it is different in certain circumstances, or I mean, in certain regards. But basically, the plaintiff here claimed that the association had violated the Open Meeting Act because there were multiple emails with all the directors on the email chain where they were talking about association business. In particular, I think one reason why the plaintiff didn't like it is they were talking about plaintiff's application, a landscape application they had, also some proposed modifications to their home that plaintiff wanted to do. They wanted to apparently put in 10,000 square feet of living space under their lots, which sounds large. But the board members, talked in email about certain things, not just plaintiff's applications, but other issues that concern the association. And so they brought suit saying, you violated the Open Meeting Act because you were holding a board meeting by email. And what is important here is that the way the Civil Code and the Davis-Stirling Act defines board meeting is a congregation of a number of directors to constitute a quorum, that's usually a majority of the directors, at the same time and place to hear, discuss, or deliberate on any item of association business. And so plaintiff claimed, hey, your discussions by email violated that definition of board meeting, and you violated the Open Meeting Act. Well, the trial court, after trial, went to trial, a bench trial court disagreed and ruled in the association's favor, and the plaintiff appealed. On appeal, the appellate court really did a deep dive into the wording of the definition of board meeting under the Davis-Stirling Act. They looked at the definition of congregation, and they concluded that a board meeting under the Davis-Stirling Act meant a gathering of a quorum of the directors at the same time and in the same physical location for the purpose of transacting any matter of association business. So they basically said, in order to have a board meeting, you have to be in person at a physical location at the same time and place. And they felt like the emails where there was a lot of discussions certainly didn't meet that standard definition. They also looked at, there's another section in the Davis-Stirling Act that in the Open Meeting Act that specifically prohibits the board from conducting a meeting by a series of electronic transmissions, including email, except in an emergency. And so plaintiff was saying, well, wait a minute, this section already recognizes that board meetings can be held by email, but only in very limited circumstances. And the court disagreed and said that that section, which is 4910, is really just a third method in addition to and different from those board meetings that are otherwise defined in the Davis-Stirling Act. So the Court of Appeal upheld the decision of the trial court and said that the board members did not violate the Open Meeting Act. They did distinguish it from the Brown Act that specifically does say prevent a series of communications outside of a meeting. And they said if the legislature wanted to prohibit that activity for homeowners associations, it would have done that. But they are concluding that a board meeting has to be an in-person gathering of a quorum of the directors for the purpose about talking and making decisions. I think another reason why the Court of Appeal ruled the way it did is that no decisions were made in these email exchanges. There were just discussions, and the board still got together and had meetings where they decided the issues that were the subject of those emails. So that was also pertinent. And just a real quick side note on this, I'm trying to be quick. The association in the trial court level was awarded its attorney's fees of over $348,000. Well, that was actually reversed on appeal because it wasn't deemed to be an action to enforce the governing documents. There is a specific code section in the Davis-Stirling Act for enforcing violations of the Open Meeting Act. And under that section, a prevailing association is not entitled to recover their attorney's fees. All right. Do you want to talk about Lake Lindero quickly?
Do we have time, Lisa, or I mean, it's 1 o'clock, but
Yeah, I mean, if you want to just go over it real quickly, sure.
Sure,
And for folks that need to leave at 1 o'clock, that's fine. Feel free to, and we'll be issuing you your CLE credit. But anyone who wants to stay for a couple extra minutes, feel free.
Okay, I'll zoom through it really quickly. So Lake Lindero HOA versus Barone. Like I said, it's a recall election case. This was an 11-day bench trial, which is really long for a bench trial. And in this case, there are 450 golf course lots up in Agoura Hills. There's a 5-member board, and the defendant, Barone, was a former board member. He resigned as a board member to become the CEO of the association. So as a side note, it's generally not a good idea for associations to hire their own members. And so, that's just a side note here. So anyhow, 2019 members petitioned to recall the entire board and hold a special election. The board didn't fix a time for the special meeting or give notice to members of any sort of meeting. So the members took care of that themselves. The notice stated that it was a vote to remove and vote for new directors. They hired the League of Women Voters to act as inspector of elections. That's a good choice if you think it's going to be a contested issue. At the first meeting, there was no quorum. The bylaws provided for 50% of the membership to be a quorum. They didn't meet that. So majority of those present at that meeting adjourned and held another meeting at which the quorum requirement dropped to 25%. They met that quorum. The recall was successful, and a new board was established. And on New Year's Eve of 2019, they eliminated the CEO position. So, lawsuits ensued after a bench trial. First off, there was the complaint was filed for declaratory relief because they argued that Barone and the old board failed to recognize the validity of the recall, and they asserted that Barone was still acting as the putative CEO of the corporation. A bench trial was held. The bench trial of the court said that the bylaw provision requiring majority of membership to remove a board was legally invalid and unenforceable because it conflicted with the corporation's code. Barone appealed that. The Court of Appeal rejected his claim. It said that Corporations Code 7222 governs recalls, and that 7222 provides that members and associations with more than 50 members, if approved by the members, as the phrase is used in Civil Code Section 5034, that takes precedent over what may be in the bylaws. So anyhow, that's the gist of that. If you have a large corporation over 50, regardless of what it says in your bylaws, the corporation's code controls. That's the gist of that case. I don't want to take up any more time, but this just highlights how not only the Civil Code, the Davis-Stirling Act, but you need to reference the corporation's code when dealing with homeowners association. And with that, it's well after 1.
Yeah, and I will say we didn't get to the rest of the cases in the PowerPoint, but we have the citations and they are an interesting read. So please do read them.
Yes.
Yes, and everyone, you should have gotten a copy of these slides as a handout by email before we got started today. So look out for that. And if for any reason you didn't, you can contact me at the law library and I'll make sure you get a copy. There was one question of clarification about one of the topics you talked about, if you could briefly address. We had an attendee who wanted to know back to the virtual meetings, the new rule. They were asking, can the virtual meetings under this new law be audio only, or is the visual component required?
I don't think the visual component is required in the new statute, but certainly the audio, because it specifically does say you have to have a telephone number so that people can call in. So it actually is read as teleconference meetings is how the statute reads. So no, you don't have to have the visual component.
All right, great. All right, well, we are definitely out of time. Thank you, everybody who hung in with us for a few extra minutes. And thank you to Laurie and Jay for this great presentation. And everyone have a great day.
Thank you, Lisa.